It's 2:30. No mai haere mai ki tēnei hui. Mea whānau is online and has asked me to chair this afternoon's session. I think she just thought I hadn't had enough chairing lately, so a bit more. So welcome all, and I think we're going to go straight...
Going down.
Who's that talking online?
That was John.
Anyway, I think there might be some other councillors online, and so we'll make sure if you have questions, councillors online, that we get them. And I'm going to pass over to Sean and Adam and Hayden for the presentation. This session will work similar to the others, and that we'll have a presentation, have an opportunity for questions of our staff, and then go to questions to the panellists.
Excellent. Thank you, Chair. So today we will set before you the Independent Hearings Panel's recommendations on historic heritage, sites and areas of significance to Māori, or SASMs as they're often abbreviated. Notable trees and view shafts. Mr. McCutcheon will lead off the briefing of the content, but before we begin, I would just like to remind councillors of their powers of clarification of commissioners. Now, this is a new power that was only introduced by amendment to the RMA with the NPSUD. We are still all learning how it works, but I do remind you that your powers are to ask for clarification. The commissioners are not here to find references and reports for you or to engage in debate. So, in that spirit, I will hand over to Adam.
Through the chair. Kia ora, councillors. Thank you for having me back. I'm joined here with my colleague Hayden Beavis from the district planning team. It's a bit of a double act today. We're covering 4 topics, as you can see here on the screen. Hayden will be leading us through the view shafts topic at the end. We'll whiz through our presentation and then we'll have questions at the end, just as we did in last week's session. So as we move into this briefing, we are stepping into the overlays space. So if you recall, right back at the start of this briefing series, Sean presented a diagram to us and it showed how planning layers add up over time. We've been through all of the zone content, now we're stepping into that which overlays the zone content. So overlays. What they do is they add an additional layer of planning control to restrict or enable different types of activities and uses and include different rules from that in the zone chapter. As an example, the range of uses that could occur within a heritage building in the city centre zone is governed by the city centre zone chapter. And those provisions, those objectives, policies and rules, you were briefed on those last week. The overlay provisions include additional rule requirements and consenting matters, such as if you were to do additions and alterations to that heritage building. They add up over time. Turning our mind to the background and higher order direction for these 4 topics, you'll note that historic heritage and sites and areas of significance to Māori are matters of national importance under the RMA, whereas notable trees and view shafts are based and grounded in the amenity matters considerations of the Resource Management Act. None of these topics have any higher order national direction or specific national direction, which informs and directs councils on how they should assemble their planning provisions to manage these resources. We do have regional direction, however. In the context of the historic heritage provisions, the regional policy statement, the RPS, and we've brought some submissions to you on the regional policy statement in recent months, sets out how historic heritage places need to be identified and considered as to whether they meet the criteria for adding into a district plan through a plan change process. For example, a heritage building could have important historic values, such as representing important themes or patterns of development. Similarly, it could be associations with important people or events. It could also be, for example, as a good representative example of an architectural style, be a rare place, or have social values such as being held in high esteem by the community. So the RPS tells the district plan how it must consider places for entry into the heritage schedules. Similarly, for sites and areas of significance to Māori, the RPS directs councils to work with mana whenua to identify sites and develop provisions to manage them. There is some general direction for notable trees and view shafts in recognising that there are natural and physical resources that may be of importance to people. Turning our minds first to historic heritage. So in this part of the presentation, I'll talk about heritage buildings, structures, and heritage areas. It's important to note for heritage areas, they're made up of buildings that do contribute to those values, called contributing buildings, and those which don't, called non-heritage buildings. I'll also talk to archaeological sites. As you can see here, with the exception of the archaeological sites provisions, all of the historic heritage provisions are proceeding through the intensification streamlined planning process. An issues and options paper was undertaken for the historic heritage chapter to turn up what issues there might be with the operative district plan provisions to help inform the new proposed district plan provisions. Considering the city's seismic challenges, there was a focus on, when reviewing the operative plan settings, to ensure that the proposed district plan wouldn't unreasonably constrain and restrict works to increase resilience. One of the responses was to permit internal seismic strengthening, so often called K-brace, through shopfront windows, and to provide some specific consenting direction around the removal of unreinforced masonry chimneys. And that reflected that the Building Act had changed after the Christchurch earthquake to make that a permitted activity under the Building Act process, so you didn't need to get a building consent. So there were some regulatory differences between the RMA and the Building Act. In terms of sustainable long-term uses, the operative plan had quite a focus on singularly protecting heritage values at a policy and objective level, and didn't recognise the role and contribution of heritage places and what they could contribute to in terms of a well-functioning urban environment. Considering the heritage schedule, heritage areas were last added in 2011 through a plan change, and heritage buildings in 2007. The council holds a database of around 600 places that have been nominated by members of the community, interest groups, professionals, and ones that have been unearthed through research the council has done, of places potentially having significant historic heritage values that, through further research, may prove good candidates for addition into the heritage schedules. In 2013, relatedly, the council undertook a thematic review of Wellington's heritage. So that piece of research identified what were the key themes in the development of Wellington City over the years. And what it did was it pulled out specific themes and sub-themes against which the heritage schedules could be assessed for their representativeness. So one of the key considerations in determining what of that 600 list of nominated items should proceed through to the proposed district plan was about increasing the representativeness of the historic heritage schedule. So that exercise of reviewing the operative district plan list showed that there were a lot of villas and bungalows on the list, but perhaps there might not be so many modernist or different types of architectural styles represented by the current heritage schedule. The items that were prioritised for further research and then inclusion into the notified proposed district plan schedules were those that were identified by Heritage New Zealand Poheretonga as Category 1, Category 2 or historic areas, but not listed in the district plan. So noting that the council does have an obligation under the Resource Management Act to have regard to the Heritage New Zealand list when it's reviewing its district plan. It also turned its mind to prioritising those which were good examples of particular places and that the council already had good research on, and those that could increase the representativeness of the heritage schedule. So that was the methodology that flowed through to the notified proposed district plan list. Considering submissions, the key matters are identified here. There were some submitters who said that the provisions in the notified plan were too permissive, while on the other hand, some saying that they were too strict and were a barrier to reuse and adaptation of places. There was also commentary on whether the provisions took too much of a focus on enabling works to occur to places, and some considering that they should be focused on conservation of places. Some thought that the settings for earthquake strengthening and increasing resilience were too permissive, whilst others thought that they were too strict. Considering the listings and the process of identifying what should be put forward onto the notified schedule, owners of notified places were typically opposed to their property being identified as having heritage value and included on the heritage schedule, while interest groups typically supported the identification of new places. Turning our mind to the key recommendations of the panel, the operative district plan, as I noted before, only has one objective focused on protecting historic heritage values. The panel has recommended 3 objectives for the historic heritage chapter, being that heritage is recognised for its contribution to the understanding and appreciation of Wellington City, that it is maintained and resilient, and that places are kept in a sustainable long-term use. The panel has also recommended a suite of policies dropping down from these objectives, requiring decision makers to look favourably on works that enable places to be kept in a sustainable long-term use, increase resilience, promote or enhance heritage values, or increase accessibility to heritage places. In terms of some specific changes to the rule mechanics, the panel has recommended that double glazing existing windows and visible internal seismic strengthening, that K-bracing through shop fronts, be controlled activities. The colours in the slide here demonstrate how from the operative district plan we've moved to a more permissive regime overall, where resource consents for retaining existing windows but adding new double glazed panes and undertaking internal strengthening won't be declined by the council, they must be granted, but there can be some controls over visual appearance, the extent of heritage effects, to make sure that overall heritage values are protected, as well as enabling these activities to occur. Similarly, new internal floor levels can be quite a challenge to achieve in some buildings, particularly commercial buildings with really high floor-to-ceiling ratios. Think, for example, of Shed 21, the old wool store on the waterfront. That's an example of a building which has had new mezzanine floor levels added to enable apartments to be inserted into that building so that it's adaptively reused. The panel has recommended that similarly we move to a controlled regime for that activity, which cannot be declined, but there can be some conditions put on resource consents to ensure that it's done in a sensitive way to those heritage values. This is a step change from the possibly declinable restricted discretionary consent of the notified plan. The panel has recommended that total demolition must be avoided unless there are no reasonable alternatives to that activity being undertaken. This is a similar test to the operative district plan, which does set a high bar to ensuring that there are no reasonable alternatives to demolishing a heritage building. The panel has recommended that the activity status of this activity be a discretionary one. So that means that the strategic objectives of the plan can be considered in assessing a resource consent for total demolition of a heritage building. What this means is that those broader plan goals around increasing resilience, carbon reduction, and ensuring a well-functioning urban environment can be considered in these exceptional last resort resource consent scenarios. To grant one of these consents, the plan policy sets out a direction that the reasonable alternatives of maintenance and repair, seismic strengthening, adding and altering a building, perhaps increasing its floor space by doing new apartments on the top or adding new office space, repositioning and relocation must be all ruled out to be satisfied that there are no reasonable alternatives to keeping a place in existence. Considering demolition by neglect, the panel turned its mind to submissions received stating that this was a risk to some heritage places. Demolition by neglect is when places are left and maintenance not undertaken on them for a period of time, when they end up in a state which means there are very limited options to make them good again. So the panel recognised it and acknowledged that there are practical limitations under the RMA and very limited mechanisms in the district plan, or what the district plan can include to address this matter. Recognising this, the panel included additional policy direction when considering total demolition resource consents for planners to turn their mind to the financial savings that building owners may have garnered by deferring maintenance for a period of time. And there are some alerts in the total demolition rule that information may be requested around detailing the maintenance that's been undertaken to a place over its life before ending up in a situation where a total demolition resource consent is being applied for.
Take your name, Tim.
Mr. Wharton last week took you through the recommendations in respect of the Heritage Design Guide, which is that it's to be deleted. The panel considered that there wasn't a great deal of historic heritage direction in that design guide, and that the objectives, policies and rules of the plan did most of the heavy lifting there. Considering additions to the heritage schedule, the panel has recommended that 47 new buildings be added, 7 new structures, 11 heritage areas and 3 archaeological sites be included. These places are listed in a document in Diligent and are also on the website. For council, the panel has confirmed the scheduling of the Freyberg and Thorndon pools. Considering places that are currently on the operative district plan heritage list and carried through into the proposed district plan, the panel's recommended expanding the Our Lady Star of the Sea listing in Seatoon, removing 43 Gusney Street or the Tumouth building because it burnt down from the heritage schedule, removing the internal listing for number 1 Ranfurly Terrace, and removing the Salisbury Garden Court heritage area in Wadestown. As Mr. Wharton spoke to you last week about, the panel have confirmed the removal of the Civic Square heritage area and the insertion of the Tanako precinct provisions within the city centre zone, recognising that there are some listed heritage buildings within that space and those buildings that do not. The panel recommended not proceeding with some of the proposed additions to the heritage list that were on that notified schedule. These are listed here. Generally, the panel considered when places are in poor condition and need substantial remedial works to make them good again, and that could have substantial effects on their heritage values, that those listings should not proceed. Likewise, when the council's evidence base was not to a point where the panel could consider it sufficient, recommendations were not made to proceed with places. Turning our minds to sites and areas of significance to Māori, we manage...
To check, should we do all of the areas and then have questions? Because I do have a couple now on heritage.
Yes, we do.
Yeah, is that all right? I just have a couple. Sorry to interrupt you, Adam. Councillor Brown.
Thanks. I just wanted clarification actually around the demolition by neglect issue. So are you saying that effectively if I've got a property and I haven't maintained it, and even though it's hopelessly uneconomic to actually upgrade it going forward, that somehow or other my historic neglect of the property will be taken into account in the decision?
Through the chair. So what the direction in the plan will do is it will send a signal to resource consent applicants that there is some expectation that evidence needs to be provided around the maintenance that they've done to the place. It will go into the mix of determining whether there be any reasonable alternatives. So it'll form one of those, another piece of information that a resource consent planner will be able to consider. It's similar to considering at what point would have there been an intervention that could have been made, and why are we in the position that we are now, and is it reasonable that a total demolition consent be granted?
Councillor Pennant.
Sorry, I've got a few, so I'll just be as succinct as possible. 1 Ranfurly Terrace, I'm very familiar with that site. So the evidence for removing the internal listing, did that just come from the owner?
Correct. The owner made a submission seeking that 2 options, that the extent of the listing be clarified or that it be removed in its entirety, and the panel has recommended that the internal listing be removed in its entirety, but the exterior listing remain.
But there was no evidence from council or from Heritage New Zealand?
Not supporting the removal of the interior listing.
Okay. Just as, I guess you're more theoretical planners than practising ones, but if we take shed 21 and you've got I just mean it from a really practical point. Do you think the controlled rules,
Do go on, councillor.
well, the controlled rules do enough to protect the structure, do you think? I mean, like what practical effect would it have, do you think, changing the rules to make them more permissive? I can see the reasoning.
So in terms of the safety of the structure, that will of course be the Building Act.
Yeah.
And so that will be dealt with through building consent. The changing of these rules is primarily looking at making it easier to fit intervening floors into those windows.
In a practical sense, what it will do is that it sends a signal to developers that a resource consent will not be declined for adding new internal floor levels into a place. So it sends a confidence sort of boosting signal that you will get a resource consent to do this activity, whereas before it could have been a declinable resource consent.
Okay. Just my next question, it possibly flows into the next section, but the number of archaeological sites, that has definitely been an issue that we haven't protected enough. So do you think this will go far enough, given the many layers of history in our city?
Through the chair, so 3 archaeological sites are proposed for inclusion and protection via specific scheduled archaeological sites provisions. So these sites have been assessed against the regional policy statement criteria for their significance. So there are many thousands of archaeological sites in Wellington City, and they're detailed on the NZAA, the Archaeological Association website. They are managed by the Heritage New Zealand Poheri-Tonga provisions for archaeological authorities. These 3 are managed in addition to those NZAA requirements, the rules in the district plan. So there, it's got another layer of protection, recognising they meet that significance criteria. Not many district plans manage archaeological sites in this way, so it is sort of a bit of a new frontier, especially for Wellington City. So that's why there are only a few sites that have been included at this point in time.
But we could do more in the future.
More sites could be added if they're assessed against the regional policy statement criteria and included via a plan change.
Okay, if I could go back on the list, thank you.
Councillor Free.
Yeah, I presume that for Tūmath House, such as Smith House and Firth House, that our officers presented the evidence to propose them in the first place and the panel considered it?
So that detail is available on the public record on the Hearing Stream webpage, yes.
Oh, the evidence itself, okay. Okay, thank you.
From memory, Tūmath House was listed in the operative district. That removal from the list. Sorry, I'm thinking of Tūmath Building. Sorry,
okay.
I've got confused again.
This one is a residential property, I think, isn't it? Okay.
Yes, that's correct.
Too many Tūmaths. Yes, Councillor Young.
Sorry, I just missed the beginning of that. I get confused with negatives to not proceed with some proposed additions. Can you just clarify what that actually means?
They're not going to be heritage buildings.
Thank you. And what are the additions?
Through the chair, so there are this number and this assortment of new places proposed to be added, and there's a list on the website, the hearings page website, and also in diligent for you. It was just a lot of writing to include on a slide, and I know we don't like that, so there's a separate list.
What does confirmed scheduling, does that mean they will be included as heritage?
Deputy Mayor Foon.
Just in one of those 11 new heritage areas, was Green Street, Newtown considered as part of that?
Through the chair, so submissions were received in the hearings process to include Green and Emmett Streets from memory in Newtown. They have not been recommended for addition.
Okay, thank you.
Pennant, we'll go back to you, but maybe just for a few minutes, and then we'll carry on with the presentation.
Just the Salisbury Garden Court Heritage Area, did the council officer provide any advice?
Through the chair, again, that's on the public record. There was expert evidence provided on behalf of the council that area remain a listed heritage area, and I defer to the panel for their consideration of those submissions.
Okay. And can I just clarify that point? If a building is in poor condition, it wasn't listed, isn't that irrelevant in terms of its value?
Through the chair, I defer to the independent hearings panel for that.
Okay, I will ask that. Okay, thank you very much.
Okay, sorry, we'll carry on to the next section. Sorry, Adam.
All right, we'll proceed with sites and significance to Māori.
Great. As you can see here, the sites and areas of significance to Māori provisions and the schedule proceed through the standard planning process. Turning our mind to the high-level issues responded to by the proposed district plan chapter, the operative district plan does contain sites and areas of significance. All of those sites were reviewed by mana whenua with council staff to determine whether they were still of significance to iwi, and new sites were added through that process. Those which were not of significance anymore were removed, or those points moved on the maps. The operative district plan takes quite a simplified approach of these areas just being dots, whereas in true reflection of their possible scale, they're more akin to polygons. So the mapped areas for these sites were expanded in the proposed district plan. Awa or streams were also included as sites and areas of significance to Māori, and these are now identified on the planning maps and have rule triggers associated with them. Mana whenua informed council that the operative district plan provisions did not fully recognise the values that these places had for them or their aspirations. There's only one demolition rule in the plan at present. Mana whenua requested that there be a greater number of rule triggers, recognising their aspirations to see the values and the narratives of these places reflected in the development of the city. These formed the main matters in contention during this hearing, awa and the recognition of the aspirations that mana whenua hold for these places. Amendments made through the hearings process recognised that mana whenua submitted that they wanted to be active participants in the resource consent and in the development of the city's built environment in these places. So there are increased consenting triggers that mana whenua must be involved and consulted when works are undertaken in and around sites and areas of significance. Notable Sorry, I'm stopping now. Yes.
Yes, sorry. Councillor Pannett.
Nico, you didn't want to go first, or?
Oh, sorry.
Did you? Okay. Sorry? Right, okay. I wouldn't want to. I guess just want to double check that the commissioners and the council have fully covered the aspirations of mana whenua, so we haven't got big gaps, and I guess then what we do to do more in the future.
Through the chair, so in the development of the proposed district plan provisions, a significant amount of work was done with mana whenua partners to understand their aspirations and how the district plan could respond to these. So over 100 hui were held with both our mana whenua partners to understand what needed to be done in the district plan. That formed part of the Clause 3 consultation that council must do under the RMA. Mana whenua were also submitters to this process, and those submissions weighed accordingly and considered by the IHP.
It is a living relationship between three living organisations, and as such, you'll see recommendations from the Independent Hearings Panel for a Papakainga chapter and other continuing conversations that will need to be advanced by plan change to meet those changing understandings and aspirations.
Councillor Wineta, did you have a question? No, thank you. All right, we'll move on to the next section.
Great, notable trees. So we currently manage notable trees in the operative district plan, though they're known as heritage trees and they're located within the heritage chapter. These provisions fall solely within the standard planning process. Turning our mind to the high-level issues responded to by the chapter, so the operative district plan has a rather simplified approach to managing heritage trees. So there are only a few number of loose rules and some pretty unqualified rules around the level of qualification that a person must have to undertake works to trees. The notified district plan seeks to resolve that by including some specific requirements around the level of qualification an arborist must have to undertake works to a tree. The operative district plan also doesn't fully recognise the range of reasons why trees might be notable in the first place. They can be notable for their ecological value, they might be associated with an important person or event, they might just be a great example of a really big tree that we don't have much of. So they can be important for more than just heritage reasons. So that's a significant shift in the proposed district plan. Key issues in contention in this hearing revolved around a formerly permitted status for enabling trees to be removed if they were in terminal decline, as well as how do you define the area around a tree for which there would be resource consent triggers to do works under. Considering trees in terminal decline in the notified plan, these could be removed without a resource consent by way of a qualified arborist and council talking to one another and being convinced that the tree was in decline. The panel have recommended that this still require a resource consent. Turning our mind to root protection areas. As I said, this is the calculation or the measurement which protects tree root health. In the notified plan, it was based on a drip line approach, so half the height of the tree sort of spread out on the ground, or if it was a big sprawly tree, the area underneath that branching canopy. The panel have recommended a mathematical formula be used to identify that area now. The panel considered that it aligned with arboricultural best practice and the submissions of arboricultural experts in this practice, in this field. That area will also be represented on the planning maps as a sort of a indicative area, so that neighbours, when they are doing works on their own property, but there is a notable tree next door, and that root protection area extends into their yard, will be notified that they need to either undertake that work outside of that area or apply for a resource consent, even if that tree is on the neighbour's property.
I have a question on the trees. So just to clarify, the recommendation is to make it more difficult to remove a dying tree.
Through the chair, there would be a consenting process to remove a tree in terminal decline.
Thank you. Councillor McNulty.
Sorry, follow up. What's the cost of a consent to remove a dying tree, if I can ask? Average cost?
Through the chair, I believe the application fee for a non-notified resource consent is around about $2,000, but of course that's not might not be the full cost of that resource consent if the allocated amount of time isn't spent on it, so there might be a return of funds at the end of that process, depending on the time it takes to process.
Councillor Wineta.
And a final follow-up, does that contribute to the sort of log jam of resource consents that we're constantly working through?
Through you, Madam Chair, I mean, I might just intervene here. So on top of that, Adam, there'd be arboricultural reports, I suspect, for and against, depending on council's view. The log jam, councillor, actually we are very low on our volumes at the moment. That's due to the market effectively being a bit suppressed. So we haven't modelled what this would be from an impact point of view. I think I wouldn't imagine it's more than a dozen applications a year, if that. So I don't see it to have a huge impact.
Councillor Randall.
Is the resource consent fee always charged? And what happens if there's a health and safety issue with the tree in terms of us making sure that people are safe? And does that affect the process?
Through the chair, so there are some permitted activity standards in the recommended chapter that if there is an immediate risk to health and safety, that works can be undertaken to that tree, provided that council's advised, I believe it's an hour before those works being undertaken. So there is still a fallback there if a situation is urgent that works can be undertaken without a resource consent. The other part of your question.
It's really, if there is a prospective health and safety risk, whether or not that would affect whether or not the council would charge a fee for the resource consent and the supporting things, because obviously if a tree is dying and people's houses are maybe at threat, or access ways or walkways may be at threat, we want to follow a good process, but the financial burden may be a barrier for people to follow a process to make sure that people are safe.
Through the chair, yes, as I mentioned, if there is an immediate health and safety and that's sort of validated, so it's everyone's in agreement that there's an immediate risk and works are undertaken, then it would meet that permitted activity standard. But if there is some disagreement and it turns out the tree perhaps wasn't an immediate risk, then enforcement action could be undertaken, like we enforce other breaches of rules in the district plan. But again, it would depend on the circumstances. Perhaps a retrospective resource consent might be required.
A couple of more on the trees. Councillor Chung.
Are there any penalties here for disregarding the registration of a tree? Like, we had an example of a protected tree in Kandala, and the council declined removing it because it was of significance. Then mysteriously it was poisoned, and then of course it was in danger of falling down, and so it had to be removed. And so of course immediately after it was removed, the owner of that site built another townhouse on that site. So is there some sort of protection or anything that we can actually do or in plan?
Through the chair, I think you might be talking about the tree on the corner of Box Hill and Baroda Street in Kandala, which was removed, I think, after it was ring-barked a number of years ago. I won't speak to the details of that specific case, but essentially this is that's an enforcement situation which we're talking about, where our council's enforcement staff may take action in that circumstance. But yeah, it will depend on the context.
So the RMA does contain the ability to charge people and take them before the courts should they disobey its provisions.
Good practicing knowledge of the trees there, Adam. Councillor O'Neill.
Just quickly, did the council supply evidence to the panel in regards to the impact of significant trees on infrastructure and investment, such as the accessibility of our footpaths, our water infrastructure? Noting in my ward we have quite a few pūrakawa that damage crucial water supplies.
Through the chair, to some extent those matters are yet to be heard, so the infrastructure chapters haven't been heard yet within this process. Those standard planning process hearings are underway now, and that matter around managing unique values and infrastructure, so heritage places and infrastructure, notable trees and infrastructure, will be revisited later this year. So those provisions will address that kind of matter and take potentially a more lenient or a slightly different approach to managing these values and enabling infrastructure to be built.
So those recommendations to come later, will they have the ability to influence the ones that we're discussing right now?
Through the chair, the infrastructure provisions will supersede the notable tree provisions themselves if the work is being undertaken for an infrastructure purpose, so that they have this overriding sort of directive.
View shafts.
Through the chair, kia ora. My name is Hayden Beavis. I'm an advisor in the district planning team, and I'm the view shaft topic lead, so that's the chapter I'll be taking you through today. So I thought I'd start first with what are view shafts. So view shafts are a mechanism within the operative district plan and the proposed district plan to protect significant views across the city. So how do these work? If you can imagine you're looking at something, you've got the cone of vision from from your eye to what you're looking at, which is, as I said, like a bit of a cone. And the plan seeks to limit development within that cone of vision to protect the view. And you need a view shaft consent if you're within that view shaft. So the plan also defines the spatial extent in which development is limited by a consenting requirement. So it does this through two mechanisms. The first one is the view shaft overlay, which is on the mapping. So this shows a sort of 2D cone from the starting point until the end point, and it shows the left and right margins as well. And you can see on the mapping whether your property is within that view shaft overlay. This isn't the only spatial mechanism used to define whether you're within a view shaft. So the second part that you'd look to is the view shaft schedule, which contains multiple spatial parameters. And the view shaft schedule first begins with a photo of the view shaft, which is what you can see on the screen at the moment. So this is a photo taken from the beginning of one of our view shafts. And you can see that there's a sort of window cut out of the subject of the view shaft. So this is used to determine if the building is within that window, then you're pretty likely to need a view shaft consent. Also within the schedule, we have spatial data about the left and right margins, which is in the form of a point on the mapping. So you'd go from the starting location to that point, and those lines would draw out, and that shows a really definite sort of left and right margins. And then you can sort of think like if you're within the left and right margins, then you need a consent for a view shaft consent. If you're without those, then you won't need a consent because you're not within the view shaft. And the final important spatial parameter within the schedule is the base layer. So as you can see on the photo there, there's obviously the bottom margin of that frame. So view shafts don't apply completely vertically. So if your building is below that bottom margin, then you would not even need a view shaft consent because it's not blocking the view. So the view shafts chapter and the schedule that I mentioned before are both notified under the ISPP process, so they are cannot be appealed. So the high-level issue is responded to by the view shafts chapter. So under the operative district plan, a few of the view shafts had been compromised. So this was we had a few overlapping view shafts. They had the same sort of point of interest, and they were protecting the same thing. So they sort of, at least one of them was sort of rendered pointless. The second key issue was public access. So a key element of a view shaft is that the public can access the beginning point so they can see the view. Some of them had inaccessible or starting locations that were in private buildings, so that's obviously against the definition of a view shaft. And the final one was that the view can be compromised over time, so that may have been built out. The PDP responded to these by removing view shafts when they're or amending view shafts when they're no longer fit for purpose. The operative district plan also had implementation issues that the PDP sought to fix with stronger policy direction and consenting requirements for view shafts. The second high-level issue is the alignment with national direction through the MPSUD and MTRS and how that's reconciled with the view shafts. So as you can imagine, in the medium density zone where you've got MDRS buildings, they can required to be able to build up to 11 metres. If you're within a view shaft and need a consent, then that's at odds with being able to build to that 11 metres. Likewise with the high density zone being able to build to 21 metres. The PDP responds to this by applying view shafts to residential zones, which they did not in the operative district plan. It's only applied to the central area in the operative district plan. And then also allowed the building within a view shaft up to 11 metres within the medium density zone and up to 21 metres within the high density zone. So an overview of the submissions for view shafts, we had 60 submissions and further submissions in total, and they primarily focused on the mapped extent of the view shafts and the application to other residential zones and other zones. So the key IHP recommendations that came in the report was the application to residential zones, as I mentioned before. So this helpful diagram will show that under operative district plan, because view shafts did not apply to residential zones, you could build as high as you want within a view shaft in a residential zone because the rules did not apply. Under the notified district plan, you required either a restricted discretionary or a full discretionary consent, depending on the view shaft, within a residential zone, regardless of the height, which was at odds with national direction. And then under the recommendations, the IHP recommended to amend the rule framework to allow building up to those heights within the view shaft. But then you would still need a consent going above those heights within a view shaft. The IHP also confirmed the application of view shafts to residential zones. And so those were the key issues addressed by the recommendation report. So the high-level outcome of this report is that you can do your MDRS, you can build up to 21 metres under the MPSUD in the high-density residential zone, but it also seeks to protect view shafts as well, so you still need a consent for a view shaft above those heights within those zones. Cool.
Very good. So
was that a question about view shafts? Okay, Councillor Pennant.
Sorry if I've missed something. Can you just clarify that? So the 21 metres wouldn't intrude on the view shaft that much?
So some modelling work was conducted to test the areas of the residential zones where view shafts applied, and the modelling work showed that they didn't have a significant impact on the view shafts. So
that's a word I'm always uncomfortable with planners. So what does that mean by significant? It's not significant?
Yeah, so for example, so the photo we showed you before, underneath the view shaft from the cable car there. So there was a bit of backwards and forwards in the heights that could be present on that site. So if they were to be 21 metres, for example, then the view shaft could be compromised by a building out to it. It turned out that the panel was recommended that not be the case in terms of the height on that site. So there's only that 11 metre height. Above that, if a building were to go beyond the height and then potentially intrude into that frame, it would require a resource consent. So it's trying to find that balance of
at the bottom part of the frame.
Yeah.
And so view shafts, can they be qualifying matters?
Yes. So the reason that the rule framework's been recommended in this way to allow an MDRS development to go ahead means that it's not a qualifying matter. So it can build up to 11 metres as a permitted activity. And the modelling work that Hayden referenced shows that 11 metre buildings won't compromise these view shafts.
Okay. All right. Thank you.
Councillor Brown.
I confess to being somewhat lost actually in that part of the presentation, but is this getting more permissive or less permissive?
I'd say it's more permissive than the notified plan because you're allowed to build up to those heights in the residential zones.
No, from my reading of the plan, oddly enough, this makes it much clearer than the operative district plan is now, particularly in the geometric extent of the view shaft. So what I mean by that is under the previous district plan, the actual margins of these things were quite difficult to define. The new way that the proposed district plan lays them out and the additions by the independent hearings panel make it much clearer for consenting planners implementing it.
Councillor Free.
I'm struggling to understand that. Thank you. That was helpful. So it's all. Are there still view shafts at street level that will protect some of the views when you're actually a pedestrian, or are they all gone? Like, for example, there was one on Whitmore Street, I think it is, looking out to the sea.
Yeah, through the chair. So yeah, we've retained, I think, all of the streetscapes, the ones that go through the streets. So yeah, they're all still in the schedule.
And did you add any more? Did you add any new view shafts?
No new view shafts were added.
Okay.
Councillor Chung.
Is there any definition of what the view shaft is actually aiming at? Like, could you say that the view of a harbour, of course, is a lot more pleasant than, say, of part of the city? So would that same condition or same criteria be applied to, say, a city view or rather than a harbour view?
So each view shaft contains a focal point, which it defines what that view shaft is looking at. So, for example, the one that's on the screen there is looking at Soames Island, I think.
So back to you, Sean, for telling us what's happening next.
Very good. I'll let Adam and Hayden take their seats.
Thank you. Thank you.
Yeah. And we'll call forward our independent hearings panel to the table for matters of clarification. whilst they're coming forward, I'll introduce the next topics will be natural hazards, three waters, noise and earthworks. And subdivision. That will be next week. We'll also be going over how the amendment process will work for your decisions when they're brought before you. After that, there will be 2 question and answer sessions, and those are designed once you have all of the information set before you to consider the district plan in the round. Very good.
Thank you. That's the second time I've heard that expression about in the round today. And it makes us feel quite Shakespearean. Right, so I'll take questions. So Councillor McNulty.
Kia ora, welcome back. There's a lot of interesting stuff in the heritage chapter. I was interested in the British Imperial tank at 139 Park Road because it's quite brief what's contained in the report. So after some clarification around how did you weigh up, say, the value of economic activity that would be delivered, to the Wellington region by allowing Weta to utilise that site versus retaining a structure that's, it's inaccessible to the public, it's rusting, decaying. I was wondering what the sort of weights were in the process of decision making around there.
That was one of the areas where we had submissions that focused on the economic return. The submitter didn't appear and didn't give us any evidence on the heritage value, as you said, was it in poor condition? Had that affected the heritage values? Absolutely zip. And so, because the focus in the heritage chapter is on heritage values, working to a legislated instruction to recognise and provide for significant heritage values, if it was really a matter, we needed some evidence to cast, like the other point in the equation is sitting alongside, we had council expert evidence saying it retained heritage values. If we didn't get anything to cast doubt on the heritage assessment, the economic return didn't take us anywhere. But whereas in a lot in the areas where we knocked back, typically we either had landowners presenting evidence that it wasn't the integrity wasn't as high as had been assessed, and with like proper evidence, producing photos of changes, and then that brings into the play. So you're lowering the heritage value, and then you bring into play, well, what is the economic return on the other side? But we're like the tank, we had absolutely zip. We never really got into the second stage because there was nothing to contradict the council evidence.
No, thank you. That makes sense why you didn't have much to be able to write about in the end then. I was just also wanting to clarify, where you've expanded the character protection overlay, was there any evidence provided, or if there was, what was the weighting given to, the condition or the quality of housing in those areas where you were expanding the character overlay? Did anyone...
Are you talking character or heritage?
Sorry, the character overlay. Character overlay.
Character overlay. The character overlays, the assessment of character was based on a site-by-site assessment that Boffa Miskell had undertaken that was before us, that had a multi-stage thing from, I've forgotten what the steps were called, but were basically, the bottom was detracting, there was neutral, and then there were 3 stages, and Boffa Miskell had assessed the character, had assessed the condition as part of their assessment of where it fitted in that multi-stepped. That was, and that was what we relied on from that perspective.
Okay, that's fair. So that was everywhere that the character overlay was expanded. Bothamist School did that assessment.
Yes, like it was huge.
Yeah, entirely guided by Botham. Yep, fair. And actually, there's a few things that have come from that. So there's this idea that demolition is only an option in the case of heritage if there's no reasonable alternatives. Was the panel provided any evidence around the significant cost impact that sort of status built in terms of, requiring legal services? Was there anyone saying that this is a significant financial impact for us or burden for us to overcome as an occupier?
That one of the parties, at least, I could. Obviously, we had a huge amount of evidence, but I have a clear recollection that one of the parties who opposed, one of the landowners who opposed a heritage listing, the second Tumouth building, the one in Mount Vic, as opposed to the one in Gusney Street that burned down, the house at Mount Vic, the owners brought a lot of material on exactly that. They had a valuation about of what the impact on the value of their house was from a heritage listing. They had information about consent costs and legal costs, and they also had evidence about the condition of their house. So they had the whole 9 yards. Yeah. And we accepted their case that their house should come off the listing. Yeah. But because of that, we had it was reasonable to infer that those kind of costs would apply across the range, and that comes back to my previous point. If people could erode the heritage assessment, cast doubt on the council's heritage assessment, then issues like that came more sharply into play. Yeah. And if they couldn't, then we felt that that the heritage, given the legislative provision, then the heritage direction prevailed. But that was the dynamic that we were operating in.
And so, I hope this is a. No, I'll come back for now. Thank you.
Councillor Wineta.
Tēnā korua. Hey, first of all, I want to just look at an aspect of MHUD's submission which stuck out to me. So in the case of the Section 32 reports for the NPSUD, which formed part of their submission, did you consider that expert or non-expert advice, or did you just take it as a given?
That MHUD was a problem because they arrived with a corporate analyst who who didn't profess allegiance or a commitment to apply to comply with the code of experts. And I asked their lawyer. I think I may have covered this last week, but I asked their lawyer, well, what are we supposed to make of this? Because you had a non-expert corporate analyst giving us a whole lot of highly technical economic material with no ability to ask him to explain it to us. And the MHUD's lawyer said, well, you give weight to it, the same weight to it as you would to a corporate witness, which is not a lot. So, yes, there was expert material, but there was no one to speak to it. So, so the end result, the bottom line is limited weight because there was no expert talking to the material.
Okay. Why was Victoria University of Wellington's submission on Gordon Wilson Flats characterised as being without evidence?
Because they didn't turn up and they didn't give us any evidence.
So in their submission, it makes quite specific reference to Architectural Centre and Wellington City Council 2017, which went before the Environment Court,
Yep.
which has quite a wealth of evidence which supported the statements in their submission.
That's right. It comes back to the fact that their submission said the Gordon Wilson Flats were I think it was, I did look at this, was of insufficient heritage value to justify continued listing. As I say, they didn't show up to the hearing. I'm well aware that there was a decision. The end result of the decision was, of course, the Environment Court decided that it was a split decision, 2-1, but they decided the end result was the Environment Court decided it was of historic merit. The university didn't show up. They didn't give us any evidence to explain why anything had changed since the Environment Court's decision. So yes, I'm aware there was a wealth of evidence. The university didn't give us that evidence. They just referred to it, I think. I can't remember, but certainly. So we go back to it's like a larger and more prominent version of the Miramar tank, where we had the council's expert saying the heritage was justified. We had Heritage New Zealand saying it was justified. We had an interest group who also called a heritage witness saying it was justified, and we had absolutely zip from the university to put on the other side of the equation. And obviously it's one of the most prominent and controversial heritage listing. I was expecting, well, to put it bluntly, I was expecting a massive scrap, and the university was nowhere.
So do you feel that showing up in person is a deciding factor on the validity of someone's submission?
It's a huge. It's when you're weighing a submission against expert evidence, where you have a real live witness sitting in front of you. It is where you have a submission and nothing on the other side, the submission might prevail depending on what it's about. But there's no one. It all depends on the circumstances.
Thank you,
Councillor Pennant.
Thank you. Just start off with 1 Ranfurly Terrace.
Yes.
Excellent owners, beautiful building, but you decided to remove the internal listing. Obviously, it's unique. And just sort of what evidence was used to remove it?
It's a difficult case. We had the owner who gave us, I'll say, an impassioned statement of how difficult the internal listing made for his and his partner's use of what is a residential home. We also felt that on the account of the reason why the internal space, and we took a site visit, and yes, it is impressive. We also felt that the history of the place seemed to be that it had fallen into the council's lap. Mr. Emeny was a plasterer, and he did all his own ceilings and when he died, his family volunteered the house for listing at the same time as they put it on the market. It was all a bit unclear the extent to which the new owner knew about this, so we didn't make any findings on that. But it seemed that the council had grabbed hold of the listing because it was impressive, but there was no comparative analysis. Well, is this more impressive than any number of other buildings that they don't know about? That was a factor in our reasoning, but mainly it was about what we felt that in a privately owned residence, restricting basically any alteration to the internal works, it's down to putting a picture hook up needs a resource consent because you're altering the fabric of the building, of the inside of the building, was an unreasonable imposition.
Okay, thanks.
Or in cutting to the chase, if the council thought that it was of such significant merit that it ought to protect the internal, then it was inconsistent with the status as a private residence.
Okay. I'm not here to argue here, obviously.
Yeah, but
so now I understand your reasoning.
But that was the chain of reasoning that led us to that conclusion.
Look, I'm just curious if you think that the RMA gives enough consideration to different levels of history, different layers, as there is conquest or colonisation or just general sociological, technological change.
Coming back to, we actually had a submission that the plan should recognise and rank heritage significance. The problem was, it's one of these good in theory, but what provisions would implement that ranking and how would you decide what was in each rank? And that was completely at large. Now, I don't think that we came to a landing as to whether we agreed with the concept because there was no follow-up. There was no meat that you could actually assess. How would this work? Like, speaking personally, I think there's merit in the idea, but it'd be fiendishly difficult to come up with objective criteria.
Yeah, okay, so that's a big issue. Just my last question for now. As I understood it from the officers, there was some thinking that you shouldn't list if a building was in poor condition. Is that correct? And what's the condition got to do with its value?
We drew a distinction between existing listings and new listings. We agreed that if you had an existing listing, the fact that it was in poor condition shouldn't alter the result. But equally, if you had a proposed new listing that clearly needed significant work, which would alter its heritage status, and the exemplifying example was the council's library, which of course is in the process of being ripped apart and put back together. And there were submissions that its heritage, it ought to be listed as a heritage building, and the recommendation we had from the council team was wait until all the work's done and then assess it and then decide. But we also had, again, going to the Tumouth building up in Mount Vic, it was in poor condition in the sense that the fabric of the building, the whole thing needed to be reclad. And we thought that was a significant element because once it had been reclad, it would have lost a whole lot of whatever integrity it had. And so that was relevant to a new listing. But again, you go back to the Gordon Wilson flats that are notoriously in poor condition. Like I lived in Karori. I must have driven up the terrace and looked at that dozens of times and observed it falling apart. But that was an existing listing, and so we didn't think that we could we could take account of that for precisely the reasons you're raising.
Okay, thank you. Right, so I'm next, and my first question is, can you clarify what assumptions you made about how much zoned capacity will be realised into housing?
We relied on the council's modelling evidence from Mr. Osborne, and there was a suggestion from Mr. Cullen for Kaingora that was flawed because, Mr. Osborne replied to that in his rebuttal evidence, and when Mr. Cullen gave evidence, he wrote it back. He accepted he had misinterpreted the HBA, and he couldn't rely on the chain of reasoning that he'd put in his written evidence. That's not to say he accepted Mr. Osborne's evidence, but we felt that after that strategic retreat, the extent to which he was taking issue with it was all a bit faint. So the assumptions were all built into Mr. Osborne's model. We accepted the council's evidence.
So then can you clarify how you considered the impact on the total housing capacity zoned for when you recommended significant increased character protection in the inner suburbs?
Saying we relied on Mr. Osborne's evidence. The chain of EXO was you had a given level of character precincts that had been assessed as part of the Section 32 reports. The reporting officer, Mr. Lewandowski, recommended a significant increase in the spatial area of the character precincts, and he produced evidence from Mr. Osborne that said the impact on zone capacity is negligible. And we reasoned by reference to the difference between what Mr. Lewandowski had recommended and what we were recommending, that they were on a par, they were in the same places, and that suggested to us that the same conclusion followed. There was so much headroom in the predicted capacity, it would be a negligible difference.
I think there may.
No, we're good.
Okay. All right. So essentially, the calculation that was made with existing character protection was just replicated for more character protection.
That's correct. We applied the same logic that Mr. Lewandowski had applied, and I think in the report we said it's unscientific. In a perfect world, we would have got Mr. Osborne to rerun the numbers, but we didn't have that ability. But we thought it was reasonable.
Can you then clarify how your recommendations for significant increased character protections align with Policy 1A1 of the NPSUD, which requires you to enable a variety of homes, and I'm quoting from it, that meet the needs in terms of type, price and location of different households, given that your recommendations don't significantly provide for townhouses or apartments or anything likely to be lower priced in a fairly significant location, the inner suburbs, due to increased character protection?
That goes back to your first question. There was such a lot of headroom in the prediction. Mr. Osborne was assessing all of those issues, and he was telling us that what Mr. Lewandowski had recommended would make a negligible difference across those range of issues, and we felt that that logic applied equally. In terms of provision for what it might call affordable homes, we also had, well, I'd make 2 points. The first is it goes back to the fundamental role of the district plan. The district plan doesn't drive development, it enables development. The fact that development is enabled is no guarantee that it's going to happen, and in fact it's no guarantee as to how it will happen. So you can enable 6 stories and somebody will build 1 story. So that's one side of it, that all the district plan can do is enable capacity. The second point is the lost my chain of thought. The second point is that was where Mr. Osborne's modelling came in. As regards this, what I was going to say was, in terms of the provision of affordable homes, Mr. Cullen told us that demand, supply on the ground would have to exceed demand before it would move the dial materially on price. It took down to an affordable level to produce affordable homes, and so that was another part of the equation about, well, to what extent are those policies being applied for? And lastly, as regards terrace homes, that goes to the point you asked me last week about the HBA that I replied in writing. I hope you got that response, because I went back and read the.
No, that's just sitting with me. You'll get it this afternoon. Sorry, that's my lap.
Can't wait, Sean.
So the essence of that response is the HBA modelling is that the reason that there is a shortfall on the ODP of predicted terrace housing is because developers, or the model assumes that developers will choose the higher return options of standalone or apartments, and which is another way of saying it's not that they're not being enabled by the plan, but the independent actors whose actions on the ground actually determine what is built will make different choices, utilising the capacity that the plan makes available.
I've got one final question, which is, given those kind of comments about there's no guarantee that housing will be built and there's a lack of certainty around how much is zoned for will be realised, would that not lead you to, to clarify would you not consider that given that level of uncertainty, you need to ensure that there is excess capacity by a number of degrees of homes to meet the forecast population growth?
I completely agree. And the question is, how much is enough? And that this comes back to the point we discussed last week. We had predicted demand over 30 years of 31,000 and change. We had capacity of 50,000, which seems like quite a lot. Now, if the modelling had suggested that, for argument's sake, predicted supply was 36,000, then the whole landscape would have looked entirely different, like we said in the report. At that point, you wouldn't be talking about expanding character precincts. You'd be talking about how far do they have to be pruned back. So I agree with you, but it's how much is enough, and I think that so for instance, I asked one of the Kaingora planners, well, did she accept that the more capacity you provided, the lower the imperative was to keep providing more? And she said essentially yes. She gave me a qualified yes, but it was essentially yes. So I agree with you, but it comes back to how much is enough. You tell me.
I don't think you do. I don't think you do want me to tell you. I'll move on to another councillor.
No.
Sorry, I'm meaning to be light-hearted. I'm not meaning that as any shade.
But that's right. And like I'm clarifying, our view was that the level of excess capacity was enough that there wasn't more, and that's the council's role to decide whether you agree with that.
Thank you. Councillor Brown, sorry.
Thanks. I just had a very specific question about one of the very few properties I know anything at all about, which was the Tūmath building in Mount Victoria.
Yeah.
And the reason, so I read the submission which the person who owns the property and didn't want it done wrote. So when I read their submission, I was actually quite surprised that in fact it was even considered. But just so I understand your comments, which are very helpful about why some buildings were judged to be out, i.e. theirs, whereas Gordon Wilson are still judged to be in. I thought that was really fascinating. Thank you for that. But why was the Tūmath building in Mount Victoria actually considered to go in the first place? I mean, what obliged that household holder to have to spend all of that money and make all that effort to keep their property from being listed as a heritage property? I mean, how did it get to that point where they were even considered and they had to go through such an enormous, expensive, elaborate process to keep their property out of heritage?
So I think at that point, that's a question you need to ask the council team. That we were addressing a situation where in the notified plan it was listed and whether it stayed listed, and we found that we weren't comfortable with the basis on which that decision. But as to the merits of the original decision, that's something the council will have to talk to you about.
So to answer that question, there were a range of buildings that were proposed by interest groups, members of the public. They had been kept on a list that had built up over time. That list had been assessed, and those that had merit had been put forward during the draft district plan and the notification of the proposed district plan process. So that's how it got before the commissioners.
Very short. In that case, sorry, if I could just follow up on that then. But was there no sort of consultation so that the property owner had a chance before it went to the commissioners? Because I could see the amount of, just from the material which I saw, they obviously spent a lot of money and a lot of energy and a lot of angst to keep themselves out. And I just wonder if the council process couldn't have allowed them greater opportunity to have, cut it off at the pass, so to speak.
So there will be many lessons learned from this process, and one of the lessons which is already on the list is looking at how the consent for things to be on that list for consideration of heritage are proposed. But some of those things are years and years old, and how that is worked through with landowners and how they are consulted.
So, Sean, just for clarity though, this particular building that is being discussed is the Tūmath House building?
Yeah, so it
was already listed?
No, it was listed as...
Thank you.
No, from memory that was listed during the proposed district plan process.
Adam's just here to answer that.
Oh, there he is.
So am I on? I am, great. Through the chair. So the building at 28 Robertson Street was included on the draft district plan heritage schedule, so it was initially floated for consultation during the draft district plan process. I believe the owners made a submission on that process. It remained listed and in the notified version approved by council.
Okay, all right. Deputy Mayor Foon?
Kia ora. Just a clarification on the reason for not recommending Green Street and Emmett Street as historic streets in Newtown. Character? No, I thought they were going for heritage.
Both. So, as I say, which would you like me to talk to, or do you want me to talk to both of them?
Both would be useful, thank you.
Character, because the areas lack critical mass. We thought it was important for character purposes that there be a sufficient area to that we called it critical mass. There was no magic in, well, how big was big enough and how small was too small. But we had submissions that a small group of houses in Selwyn Terrace be identified as character area. We thought that didn't have critical mass, so that was the reason on character. I think the answer on heritage, I'd need to go back and reread what exactly he said, but I remember we tested with a council expert whether the heritage of Green and Emmett Street was linked to the heritage of the shops on Ridderford Street. Because when we went for a site visit, that was to our untrained eye, it appeared like they're really short streets, and they appeared to be orientated to the shopping area rather than to some broader heritage residential area. But one of the problems I said last week with site visits is that it's really dangerous for panels to form views on site visits, because the role of a site visit is to explain the evidence, to get a clearer fix about what the evidence means rather than to create evidence. So we formed this lay view, and so we tested it with the council expert, and she said no, that the heritage value of the shops was quite a distinct issue to any heritage values of those streets. And ultimately, we didn't have any heritage evidence to contradict that view, and so we ran with it. That's my recollection of the chain of reasoning.
Actually, can I just go further? So this is just from memory, and I haven't got access to the information in front of me. There was a particular building that is the oldest building either on that street or in Newtown. Was there any thought given to that particular house and the heritage value for that?
I can't recall that we had any evidence on any individual house from a heritage perspective.
Okay.
That's not to say there was none, but I can't recall it.
Okay, thank you. I'll look it up. Thank you.
Pauiwi Hohaya.
Yeah, kia ora. I'm just trying to understand, just trying to get clarity around something. So you mentioned you give greater weight to evidence when a submitter appears before the panel?
It depends what's in their submission.
Yeah.
Because this goes to an issue I talked about last week, because you say, well, what is evidence anyway? And there are legal textbooks written on this subject, and part of the issue is when a submitter appears, you can ask them questions.
Yep.
That's a key element in sort of gaining confidence that whatever they put in writing is well founded. You can test what they say in response to your question. You can form a view. You can ask them about logic gaps, and if they have good answers, then immediately then the weight of what they're saying goes up. And if they have poor answers, the reverse occurs.
So just to clarify, is that sort of a convention, or is it something that's set out in the legislation as a kind of preference? Or
no, it's not. It's a huge body of law, because every legal case will turn on the evidence. So there's massive amounts written in the legal textbooks about giving weight to evidence and the kind of factors you take into account. It's not in the legislation, but what the Environment Court practice note, which we take our cue from, says is you start with the rules of evidence, which are the legal rules of evidence that would come to play in a courtroom, and then you can modify those, but with care. And,
thank you.
And so that's the origin of where those principles come from.
No, cool. Thank you.
Councillor Wineta.
Thank you. So I'm really trying to appreciate this process by which things were considered for heritage scheduling based on your reads of the evidence. If someone gave you evidence with regard to the condition of a particular item, or sorry, a particular location that was suggested for heritage listing, would you be able to take that into account?
Yes.
Did you?
But this comes back to Councillor Pannant's question, that we took it into account principally for new listings. We didn't think it was nearly so relevant for where existing listings were being rolled over. But it also goes to the point that Mr. McCutcheon raised. How did it get to this point of poor condition? So again, returning to the Turmouth House in Mount Vic and the Such Smith House in Brooklyn, the evidence we had was they were in poor condition because the choice of materials for the site was fatally flawed. It wasn't because they hadn't been looked after.
Okay, so you can take into consideration condition. What about intent of the relevant parties to develop, demolish, not develop, refurbish, etc.? Can you take that into consideration? And if so, did you?
To a much lesser extent. So, for instance, the trustees who own the Such Smith said house based their case on the fact they wanted to at least be in a position to develop the site. And I don't think we gave that much weight at all compared to the fact that we thought that the assessment of the historic merit of the house was flawed because it hadn't considered the amount to which it had already been modified. So, so the answer to your question is probably not to any material extent. Like that was part of the picture, because if so, for instance, another example was there was some people who suggested that their house be listed. I think that was in Mount Vic too, the Dobson house, where the owners were suggesting that it be listed, and obviously they weren't intending to develop it. And so that came into the frame as part of the equation.
Okay, final question. Did you receive any evidence throughout the course of the hearings that might suggest that the presently high cost of development would continue throughout the life cycle of this district plan?
That was a question I think somebody asked me last week, and I said, Mr. Cullen gave evidence that it was abnormally high, but didn't suggest when we would return to normality, whatever that might be considered to be. So that was certainly in our frame.
Mm-hmm. But is it fair to say the assumption is that, based on the evidence you received, the current cost of development will continue for the 30-year, decades-long life cycle of this district plan?
I think it was more that we had no confidence as to when it wouldn't prevail, no material as to when it wouldn't prevail, but we also, I think, had a natural human cynicism that in our modern world, prices ever go down and whether they just don't go up quite as fast.
Okay, thank you.
Councillor McNulty.
Thank you. Just having a quick skim read of the Boffa-Miskell report you mentioned before about character overlay. I just want to confirm, unless there was evidence to the contrary, that was essentially face value, or that was the baseline that you used, the 1930s character overlay report.
I can't remember what it was called. I would need to give you a specific reference. But the key element that was presented to us in the staff report were a series of maps, colour-coded maps, on a site-by-site basis, as I said, in the spectrum. Now, as I say, I would need to confirm exactly what the report was called.
Yeah.
You might well be right, but I can't recall that. I just have this vivid impression of these maps because that's what we poured over.
Yeah, no, I've just seen them too. So basically, that was your baseline, was what was in there. Unless you received evidence to the contrary, that was your guide of what constituted a character area. Would that be fair?
Well, that was the input as to from which you might derive a character area. Like Boffa-Miskell actually made their own recommendations, but we went back to their source, their raw assessment site by site, because that's what Section 77L requires us to do, which was to undertake a site by site analysis.
Cool. So just trying to getting my head through the process. So, because their methodology, as you said, it was basically this many are additive, this many are neutral, this many are detractive, and ergo that creates a precinct. At least that's my interpretation from the skim read. So if homes within one of those overlays, were in poor or dilapidated condition, the approach was still, though, to essentially apply it across the area. Is that fair?
Well, the way I read their report was they had taken condition into account when ascribing the quality of the individual properties. And so we were looking at those maps, and it's Dr. Jacobs, who gave evidence for Heritage New Zealand, described the process of drawing boundaries around, he said heritage areas, but he said character areas the same as it's as much an art as a science. And Mr. Lewandowski, the reporting officer, gave us a really comprehensive and specific analysis of why he had recommended his boundaries, which, as I say, were a significant increase on the notified provisions, and it was a really good analysis in his rebuttal evidence, and we went through it, and we had difficulty. We were comparing effectively the consistency of the judgments he'd made in this place versus that place, and so we formed a different view, but that was the nature of the exercise. And Mr. Lewandowski described it as I think he said subjective, and I don't think we disagreed. We just had a different subjective view to Mr. Lewandowski on that character assessment based on the Boffa-Miskell underlying assessment.
Thank you. And last one, and there's a considerable number of recommendations, obviously, the panel's come to through this process. So in the interest of saving time, were any of the recommendations not unanimous? Any of the major ones? And
no.
Which ones were they?
No, I'm not saying there were that there were none that were not reached without difficulty by talking around, but there was nothing where at the end of the day anyone had any serious reservation of position. Everybody signed up to what we were recommending.
Cool. Thank you very much.
Councillor Brown.
Thanks. I was just reading an email that we received from a guy called...
Councillor, so in this process, the questions are related to evidence that has been presented to the panel, or so we can't introduce new evidence into the process at this point.
No, that's fine. Okay, I was just going to reference where it came from. So the question I've got, which is really sort of his, is that apparently you increased the heritage zoning of...
Councillor, we're going to forgive you because you've been on leave in Europe, but we've got to be quite strict about how we apply questions of clarification for the commissioners.
Yeah, but this is about the heritage thing.
I know, but so in terms of the confines of what you can ask, you really need to ask what the IHP have recommended to council and matters of clarification around that, referencing or talking about any other matters after the fact. It cannot be entertained.
And to be clear, it's evidence that has already gone to them. So, for example, an email that we received would, subsequent to that process, we can't include in our factor into our decision making.
Right. So, I get that, but I guess what my question really is around character zoning of suburbs, where the overall character of the suburb becomes an important factor in terms of deciding the area that's going to be zoned as heritage and therefore, sort of not able to be built up on. How do you, and the Two-Mouth property is a good example of something where I can understand the sort of cost-benefit analysis that you've done in respect of an individual property, but when you look at a suburb where you've decided that there should be a character zone for the suburb or an area, do you do the same sort of cost-benefit analysis across, because obviously some houses are terribly dilapidated that are really, and some are much more characterful and deserving of preservation, etc. So how do you do that type of cost-benefit across a larger area as opposed to just one property?
Well, one of the things.
Is that okay? That's right.
One of the things where there's a difference is that I think Mr. McCutcheon put it that there's a high hurdle for demolition of actual heritage properties, like basically that it's a void unless you've considered all the alternatives and it's not reasonable. But the overwhelming emphasis is on preservation. Part of the equation in the character space is that it's a much lower test. Like there is a policy direction around pre-1930s character homes, but so for instance one of the tests is for in that space is poor condition is itself a reason to knock over a character home, where it's not a reason in relation to a heritage, or perhaps it will come to trees. Yes, and some of us have had 4 hours of hearing this morning on the airport issue, airport zone. And we had submissions trying to push the character provisions closer towards heritage in terms of a greater impediment to doing work on them, and that we decided weren't merited, but essentially on NPSUD grounds. Basically, it's pushing in the wrong direction, and similarly, that the standards around in the heritage areas are all MUZ standards. Again, that was something that we were invited to make more stringent standards. So, 11-metre height limit. People were suggesting it come down, and we recommended that not occur. So yes, the character precincts impose additional costs, but at a lower level in terms of at least the regulatory hurdle to do any material work on them, because the essence of a character precinct is that while it is partly about preservation, it's mainly about the overall streetscape. And so if somebody's going to build something that looks approximately like what's currently there and it's 11 metres, well, it's in the go for your life. Whereas that's not the position for heritage. It's quite different. And there's a section of our report, if you're just back from holiday, that'll cure for insomnia. About the methodology, and one of the things that we looked at is that we were at the margins. We're focused on excluding what were assessed as neutral places to pull it in, whereas we were more accepting of neutral places within that were surrounded by character places. As I say, there's a section of report 2B that discusses the kind of principles we were looking at when we were doing that, fixing boundaries and drawing lines on the map.
Councillor Pannett.
Can I just follow up with a question that you responded to from Councillor Winera? Did you get any evidence about redevelopment costs? So, once a building's built, it will need some work over time, and its costs?
Not that I recall.
Okay, so for example, the Adelaide Hotel, which has been very, very difficult and subject to lots of court action, where the costs have been quite high to strengthen?
As I say, not that I recall.
Okay. Sorry, this is a little bit philosophical, but buildings, in terms of heritage and character, buildings and streetscapes do change over time. Do you think the rules sort of give recognition to that? The ability to change, but the ability to keep what's important?
Heritage, not really, because the whole essence is on preservation of the integrity of the historic values. Character, yes, to a degree.
Mm. And the archaeological sites, which worry me a little bit, we collectively failed not to protect enough previously. And the officers responded to my question that it did go through a testing process. Is there really only 3 that are worth protecting in the whole of the city?
You'd have to ask them that.
In terms of the evidence that you received?
That was the evidence we received. And like, I'm not in a position to know how many there are out there that would deserve listing, but that was what we, and I think Adam talked about, that there are thousands of archaeological sites, and well, basically it defies belief that there aren't a few more than 3, but that was the evidence we had.
Okay, thank you.
Councillor Free.
This is just really a bit of clarification from something I picked up from your answer to an earlier question on character areas. So are you suggesting that there's really not much impediment to removing a character home if you were to replace it with something that sort of was of similar vibe?
It depends. No, I wouldn't say that, like if I created the impression that there's not much impediment, there's much less impediment than for a heritage home, but it's not open slather.
No, but
sorry, can I just interrupt? So it's clear that in the character protections in the plan, and by increasing character, that resource consent is needed in order to demolish.
Oh, okay.
Yes.
So there are some tests, and there is a discretion because I think no one suggested to us rules that would satisfy the legal requirements for permitted activity condition.
Sorry to interrupt you, Councillor, if you've got another question.
Yeah, so I guess looking at, I'm just thinking that in actual fact, would it be possible to have quite a lot of densification potentially in a character area if you've got older homes there that no longer fit for purpose?
Possible, yes. Likely, I couldn't comment. But it's also scale and degree. That with an 11-metre height limit, that's not 6 stories.
No, but it could be
3.
2 or 3. Yeah.
It's 3 stories.
Okay, thank you.
I think we've come to the... Oh, Nuruddin, sorry. Councillor Abdurrahman.
Cool. I haven't been away for holiday, but just stop me if I made any mistakes. So, I just want you to clarify for me when you talked about demarcation around Newtown example, saying that 50% of this part from Adelaide Road and Daniel Street to Rediford, and again between Owen Street and Daniel Street, and you classified and say 50% is going to be this and 25% is going to be this. Is that your recommendation, or was that the submission from the locals?
The submission, the submission was to replicate the ODP, which was the whole suburb. We weren't deciding this one will have 50%. We were doing it, the percentages came at the end of the process and fell out of where we'd drawn the lines, rather than saying, looking at a street and say 50% of it should be in and 50% should be out. If you understand what I mean, we drew the lines and then say, oh, what's the end result? We drew the lines again based on, this was my discussion with Councillor McNulty, based on the Boffa-Miskell analysis of the individual character of each property.
I think that brings us to the end of the questions. Thank you very much.
I wonder, Madam Chair, tell me if my contribution, but Councillor Free asked a question in effect about, or referred to trees, and do you want me to address that?
Talk to us about the trees.
The rationale for terminal decline was an expert witness who said a tree could have hundreds of years of life, but be left in it, but be classed as in terminal decline. And I would liken it to the fact that is the medical evidence you start losing brain cells at 18. So without wishing to cast aspersions about age, I think most people in the room are in terminal decline. So we thought...
Steady on, mate.
Us more so than others.
Some more so. But the point was, we thought, that, based on the expert evidence we heard, was that a huge number of notable trees would disappear based on that kind of test. And again, so long as the threats to health and safety were clearly permitted, that it needed a consent process around it. That was the rationale.
Thank you. I don't think there are any other questions. We're just declining even more quickly. Thank you all.